Hi everyone, this video is to provide a review of all of the content that we've covered this semester in entertainment law. This video will focus on the content covered and a summary of how to approach questions in an exam relating to the content. I'll record a separate video that focuses just on the exam and the requirements for the exam and tips for completing the exam. Alright, so the first content we covered this semester was defamation. The first thing to do in a defamation question is to look at what was said or what was implied by what was said. These are called imputations, and remember that there are three types of imputations. There is the natural and ordinary meaning of what was said. So if I say, "You are a liar," that is the natural meaning of what is said. There is false innuendo, which is to imply something even if you're not saying it. And there is true innuendo, which is an apparently innocent statement that can be combined with other information to take on a different meaning. So for example, to say that I saw Lucy walking into the building at 2 George Street, if 2 George Street is a methadone clinic or a clinic for people with alcohol problems, then anybody who knows that fact about that address will understand that what I am saying is that Lucy is a drug or alcohol addict. All right, so identify the imputations. In what is said, there might be a few different imputations, and then go through each imputation and decide whether or not it is defamatory. And imputation is defamatory if it is likely to lower the person in the standing or estimation of the community or lead an ordinary reasonable person to think less of the plaintiff. To decide whether something is defamatory, you should take into account the context of the statement. So, was it said as a joke or was it said in seriousness? What would a reasonable person understand that statement to be saying? The statement also has to refer to the plaintiff in a way that somebody would understand that reference. So a person does not have to be named, but a listener or a reader would understand that those imputations refer to that particular person. You should also be aware that only individuals can be defamed. You cannot defame large groups. So if you say something insulting about QUT students in general, then that is not defamatory. You cannot defame dead people, and you can generally not defame companies. So it's only an individual that you want to be looking at. And finally, you need to look at whether or not those imputations have been published. Published in this context means that it has to have been communicated to at least one other person. Normally, these will be satisfied. The only time when it might not be is two people in an argument calling each other names. That won't be defamation unless it's done in the vicinity of other people who can overhear that argument. But normally you'll be dealing with material that has actually been published in a newspaper or on the radio or something like that. So you look at what was said. Would it lower the person in the estimation of others? Is the person able to be identified from what was said? And has that material been published? And if all of those elements are satisfied, then so far there has been a defamation. But what you do need to consider is whether there is a defense that will mean that even though what was said might lower the person in the estimation of the public, actually under law it's okay. And there are 4 defenses that you need to be aware of for the exam. The first is truth. So if something is said and it is true or it is substantially true, then that is permissible. It doesn't matter how insulting it is. If it's true, then that is allowed under law. The second defense is honest opinion. So as long as I say something and it is clearly my opinion, not a statement of fact, and I honestly hold that opinion, then that is a defense to defamation. This defense usually comes up in the context of reviews. So I can say what I like about an actor in a movie if I'm reviewing that movie, so long as I honestly hold that opinion and it's clear that this is my opinion, then that is a defense to defamation. The third defense is consent. This might come up in the context of entertainment industries on, for example, reality television. The contestants will normally have to sign an agreement which says that they consent to the airing of anything that is said about them, even if what is said is defamatory. And the last defense, and this is the most difficult defense to get your head around, is qualified privilege. Now, these are the elements of qualified privilege. The recipient has an interest in receiving information on a subject. Defamatory imputations are published in the course of providing that information. And the conduct of the publisher was reasonable in the circumstance. So let's look at an example. This might apply for a newspaper, for example. Say a newspaper was publishing a story about the coronavirus and the government's response to the coronavirus. The public has an interest in receiving information about how our government is dealing with the coronavirus. Now let's say that in that article, some things were said about the Prime Minister that might be considered defamatory. So long as the newspaper conducted themselves reasonably in publishing that story, then they will have a defense of qualified privilege. And I'll look at what is reasonable in a moment. But first, you should be aware that the qualified privilege defense will not apply if there is malice. So that means if the publisher knew a statement was untrue and published it anyway, if they were motivated by spite or ill will, or if they go beyond what is considered reasonable in the circumstances. So how do we decide what is reasonable? Most of this is common sense, but it will take into account things like the situation in which the publisher is operating. So if we stick with our newspaper example, sometimes if it's a daily newspaper, they're under a tight timeline. If it's something like a national emergency, like the coronavirus, the time that they have to check and verify the statements might be shorter than usual. And because the information is so important to get out and get out quickly, what is reasonable in those circumstances might be different to what is reasonable if the publication was a monthly publication. You might want to look at whether a reasonable attempt was made to let the person give their side of the story or respond to the imputations. So maybe the paper should have invited the Prime Minister to comment on the imputations that say he's handling this crisis badly. If that's defamatory, then they might want to give him an opportunity to comment. How carefully the story distinguishes between allegations and facts, how carefully they check their sources, etc., etc. All of those things will apply to deciding what was reasonable in the circumstance. Okay, so 4 defenses to be aware of. You don't have to go through every single defense in every exam question. You should only look at the defenses that might be relevant on the facts. Apply those defenses, or defense if it's only one, and decide whether or not it has been established, and then conclude whether or not there has been defamation. So if the defense is established, there is no defamation. If it is not, then there is defamation. And if there's no defense, then your final step is to decide what remedies there will be for defamation. And in most legal actions, this will be an injunction, so in order to stop the defamation, and probably monetary damages as well. All right, so the next content we looked at was vilification or hate speech. What should you do for a vilification question? The first step is to decide which law you are applying. Is it the Commonwealth law or is it the Queensland law? And the best way for you to distinguish between the two for the purposes of our exam is to decide whether or not the statement that was made, which might be hate speech, is about race or not. If the statement is racially motivated, so it is about race, skin color, or national or ethnic origin, then you will apply the Commonwealth law, which is the Racial Discrimination Act. If it is about religion, sexuality, or gender identity, then you will apply the Queensland Anti-Discrimination Act. So that is your first step. Your second step then is to apply the relevant test under the legislation. If you're applying the Commonwealth legislation, it's section 18C, and you need to decide whether the statement made, which is about race, is reasonably likely to offend, insult, humiliate, or intimidate the person or group about which that statement was made. If you are applying the Queensland legislation, then under section 124 capital A, you want to look at whether the act or statement, which was about religion, sexuality, or gender, is likely to incite hatred towards, serious contempt for, or severe ridicule of the person or group about which the statement was made. The third step is to make sure, regardless of which law you are applying, that the act or statement was done in public. Hate speech is only unlawful if it is in public. If you do have speech that you believe vilifies a person on those grounds that we just looked at, then you need to decide whether there is a defense. Under both laws, it is a defense to vilification if the statement or act was done either while performing or exhibiting artistic work. So sometimes things are said during a play, for example, or if it was done in the course of publication, discussion, or debate, held for a genuine academic, scientific, or artistic purpose, or for a purpose that is in the public interest. So was this done during discussion, debate, or publication in the public interest, or that had an academic, scientific, or artistic basis? That's the first step of the defense. And secondly, was it done reasonably and in good faith? And reasonably and in good faith involves both objective and subjective components. So objective means that it's in the view of somebody else, of a reasonable third party. Would a reasonable third party think that what you said was reasonable? And that requires that you take steps to minimize the harm that might be caused. So if we think about how this might apply, in the course of a play or in the course of, say, a discussion on ABC's Q&A, maybe something is said about, let's say if we go back to the context of the debates around same-sex marriage. Maybe a statement is said during debates about same-sex marriage that might be considered to vilify people who are same-sex oriented. So then we decide, was that reasonable in that were steps taken to minimize the harm that might be caused to same-sex oriented people? And did the person who said it actually believe that what they were saying was true? So was it their belief that same-sex couples should not get married? And was it reasonable in the circumstances that they took care to say that in a way that would not cause harm? Now, if they were motivated by ill will, then they do not have a defense. And generally, if what they said is really too strong, right? If what they said about same-sex marriage is just really insulting, then it will not have been done reasonably. And so there will not be a defense to that vilification. An extra step to consider under the Queensland Act is whether the conduct is elevated to a criminal offence. And there will be a criminal offence, which means a person can go to jail if what they said is not only hate speech, but it is hate speech that threatens physical harm or which incites other people to threaten physical harm to that person or group. And if it is something that threatens physical harm, then that is a criminal offence under Section 131, capital A of Queensland's Anti-Discrimination Act, and the person who said those things might be subject to imprisonment. All right, so you want to look at all of those steps and then reach a conclusion. Has there been vilification? The other lot of content we looked at is around obscenity and indecency. Obscenity or obscene material is material that is offensive to contemporary community standards. And what you need to know for obscenity and indecency is basically how the classification system works in Australia, and also that Section 228 of the Queensland Criminal Code makes it illegal to sell, distribute, or expose for public view obscene publications, images that includes paintings or photographs, or shows or performances. If that display or sale is done knowingly, so you know the material is obscene, and without a lawful excuse. So under Queensland law, it can be illegal to distribute obscene materials. All right, so how obscenity is regulated under the classification system, which applies to movies, to books, and to games, is the principle that adults should be able to read, hear, and see what they want, but we will regulate this content to the extent that adults may be involuntarily exposed to material they find offensive, or that children might be exposed to that material, and that as a society we don't condone depictions of extreme violence or sexual violence or demeaning portrayals of people, and so we regulate those as well. So generally when you're deciding how a film, video, or game will be regulated, is that you're looking at those principles I just went over, the literary, artistic, or educational merit of the content, whether that content is for medical, legal, or scientific purposes. So for example, if it's a medical video of surgery, it's obviously going to be a bit bloody, and that is okay because it's of a medical nature. And you also want to think about what people are likely to see this material and who is it targeted towards. So then you decide how this material might be classified by looking at the features that it contains. So in the table, those are the things listed from top to bottom, running vertically, violence, coarse language, drug use, nudity, sex, and the one at the top, themes, is usually about mature themes. And then you look at what is the extent to which those features appear and are likely to impact on the audience. And if it's very mild, then it's rated G, and then we go up in seriousness all the way to RC, which stands for refused classification, which means that the material is not available to the Australian public. Slightly less than that is it's rated R, and then you guys know all the ratings for content. So in terms of impact, you look at things like, is it repeated? Is it prolonged? Is it realistic? Are there close-ups? Etc., etc. And that is how the classification board decides how material is classified in Australia. And that's really all you need to know for obscenity and indecency. The next big lot of content we looked at was copyright, and we spent several weeks on copyright. These are the steps, the first 4 steps for considering a copyright question, is to look at what type of material we're dealing with. And remember, copyright is the law that regulates creative expression. And I'll look at the different types of material in a moment. Second, who is the copyright owner? Step 3, what exclusive rights have been implicated? And step 4, have they been implicated in relation to the whole or a substantial part of the material? So let's break down those first 4 steps. What type of material? Copyright law regulates 2 different groups of material. The first group, under Part 3 of the Copyright Act, we call works. These include literary works, so anything in writing, dramatic works. This is generally scripts for plays or movies, or it can be directions, screenplays, that sort of thing. Musical works and artistic works. Part 4 subject matter deals with more of the sort of digital material. So that is sound recordings, films, and TV and sound broadcasts. I've got a notice on the slide there which says, remember that one creation may have several layers of copyright. So for example, a song that you hear on the radio, the music will be a musical work, the lyrics, because they are words, will be a literary work, and then the song will probably have been recorded, so there will be sound recording copyright. And each of those different types of copyright might be owned by different people. Or if you're looking at infringement, it's possible to infringe only 1 or 2 of those different types of copyright rather than all of them. So if somebody plays the music to the song on their guitar, then they're only potentially infringing the musical work. They're not also infringing the literary work if they're not singing the lyrics or the sound recording. So make sure you're identifying the precise type of material. All right, the second step is who is the copyright owner. For all works, the owner is usually the creator of those works. 2 exceptions that you need to know. One is if the work was created in the course of the person's employment, and if so, then the employer will likely be the copyright owner. And the other thing to remember is that ownership rules can always be varied by written agreement. So if there is a written contract that changes the ownership rules, then that will override the general rule that the creator is the owner of the work. For Part 4 subject matter, the owner is what we call the maker. And I've got down there on the slide who usually is the maker in each situation. So for sound recordings, it is usually the recording company. For films, it is usually the producer of the film. And for TV and sound broadcasts, it is usually the broadcasting company. All right, so copyright owners get exclusive rights in the works that they create. And on this slide, I've listed the different types of exclusive rights that copyright owners will hold. For literary, musical, and dramatic works, they have the right to reproduce the work, to publish the work. This means to make the work public for the first time. Once the work is made public, then the publication right is exhausted. The right to perform the work in public, note those words, in public. A copyright owner cannot control what people do in the privacy of their own homes. There is the right to communicate the work to the public. This is the right to make a work available online. So if you see that content has been emailed, posted on YouTube, posted on a website, shared on Facebook, etc., the right that you're looking at is the communication right. And finally, there is the right to adapt the work. So this includes, for example, if you take a literary work, it might be to translate the work into another language, to adapt the work, to adapt a book to a screenplay, things like that. For artistic works, the rights are to reproduce, to publish, and to communicate. And publish and communicate have those same meanings as they did for the other types of works, to make public for the first time and to make available online. For sound recordings and films, the rights are to make a copy, to cause the recording or the film to be seen or heard in public, and again to communicate the recording or the film, which means to make available online. And for broadcasts, the rights are to make a film of a TV broadcast or a copy of that film, to make a sound recording of a radio broadcast or a copy of that recording, or to rebroadcast a broadcast, or to communicate the broadcast to the public, so to put the broadcast online. You need to know these exclusive rights because the rule is that only the copyright owner can what we say, exercise these rights, so do any of these things. So only the copyright owner can do that, or somebody who has the copyright owner's permission. It is an infringement of copyright to do one of those things without the copyright owner's permission or without a legal exception. And we'll look at exceptions in a moment. It is an infringement if you do one of those things in relation to the whole work or a substantial part of the work. And you determine whole or substantial part by looking at what was taken or copied or used. You look at the quantity and the quality of what was taken in relation to the original copyright work. So if what I took from a song was important to that song, was the main couple of lines in the chorus, then that might be a substantial part. It doesn't matter if it's not an important part of my song. You're looking at, was it an important part of the original? And quality is important there. So is it a memorable part? Is it a part that is really significant to that original work? I do want to draw your attention to one important difference between works and other subject matter when it comes to exercising the exclusive rights. And that is the difference between the reproduction right and the copying right. The copying right for subject matter, so this is for sound recordings and films in particular, is the right to make an exact copy. So to copy a sound recording, I need to burn that CD, or I need to burn that DVD of that film. It has to be an actual exact copy of that sound recording or that film. Reproduce is a little broader than copy. Reproduce means that it is similar, right? So I don't have to make a photocopy of a book in order to reproduce it. It is enough for me to infringe if I write a book that is very, very similar to that first book in terms of the written expression. Maybe I've copied out some paragraphs or pages. Maybe my story uses the same turns of phrase. It just has to be really, really similar, but it doesn't have to be an exact mechanical copy in the sense of a photocopy. So that's an important distinction to bear in mind. All right. So once you've decided whether or not there's a copyright infringement, by looking at, has a person who is not the copyright owner done something with the whole of the copyright work or a substantial part of the copyright work? And the thing that they've done is something that is normally reserved only to the copyright owner. So it's one of their exclusive rights, such as copying or performing in public or communicating online, right? That's an infringement unless there is a legal exception. That is what's there in step 5. When you decide whether or not there is an exception, then you conclude whether or not there is an infringement. And if there is an infringement, what are the applicable remedies? All right, so what are the exceptions that you need to know? They are the fair dealing exceptions, and I've listed there the 5 relevant ones for you. Fair dealing for research or study, fair dealing for criticism or review, fair dealing for parody or satire, fair dealing for reporting the news, and fair dealing for access by a person with a disability. So what you need to decide, firstly, is that the act was done for one of these relevant purposes, and secondly, that it was fair. So if I copy a book, is it for my research or study? Or is it because I am doing a review of that book, for example? That's step 1. Step 2 is, was my use fair? Fairness will depend on the circumstances, but usually what you look at is whether the person has only used as much as they need to for the relevant purpose. So it will not be fair for me to copy an entire book for my research or study, but it might be fair for me to copy one chapter, which I'm going to refer to in my assignment. So use your common sense when you're looking at fairness, but it has to be for one of those purposes which are listed there on the slide. All right, if there's an exception, then there's not infringement. If there's no exception, then there is infringement. If there is infringement, what is the remedy? Normally you have an injunction, which is an order to stop infringing copyright. There will usually be a monetary remedy as well, which is either damages or an account of profit. So damages is just a payment of money. An account of profit means that if I've made a profit from my use of your copyright material, I may have to transfer all of those profits to you instead. If you're the copyright owner, then you have to decide whether or not you have damages or account of profits. You cannot get both. And if it's a lot of goods, so if I'm mass producing pirated copies of DVDs and selling them, you're also entitled to seize and destroy all my pirated DVDs. Okay, the last thing to consider under copyright is whether or not there's been an infringement of moral rights. Individual creators and performers get moral rights in addition to the copyright exclusive rights. Only individuals have moral rights, and they always stay with the creator or the performer. There are 3 moral rights: the right to be attributed, so the right to be credited for your work, the right not to have somebody else credited for your work, or the right not to have your name put on something which you didn't do. That's the right against false attribution. And also the right of integrity. Right of integrity is the right not to have your work subject to derogatory treatment. And derogatory treatment is defined as treating the work in a way that is prejudicial to the creator or performer's honor and reputation. Now, this doesn't mean that I can go around accusing everyone of infringing my moral right of integrity just because I don't like what they've done, right? Because this would mean that you could never make a parody of a work, for example, because the owner's probably never, or the creator's never going to like it if you're making fun of their work. And that is why there's both a subjective and an objective test. The subjective test is that it's prejudicial to my honor. So that is the fact that I, as the creator, am insulted by your use of my work. But there is also an objective test, which is reputation, which is would other people outside of me, people in society, think that that use demeans me or is prejudicial to my reputation. And if ordinary people would not think that, then my moral right of integrity has not been infringed. There's also a reasonableness requirement that applies to all of the moral rights, which means that if it is reasonable in the circumstances, a person may be able to get away with a technical infringement of moral rights. So if it is reasonable in the circumstances that I do not attribute your work, then that might be okay. It really depends on the context and the circumstances. If there has been a breach of moral rights, then remedies include an injunction, damages, or also lesser remedies, such as an apology or making amends. So if I publish a story and I misattribute you, then it might be enough that I publish in my next week's newspaper, I publish a statement that last week I got it wrong, and actually the creator's name is this. Right, so you can make amends for moral rights because it's not such a serious breach of a person's rights. And that's everything for copyright. Moving on to trademarks, which was the next area of intellectual property that we looked at. We looked at two things: trademark registration and trademark infringement. And for trademark registration, there's really just 3 steps. Do you have a sign that will be used in trade or commerce? So remember that a trademark is something that indicates the origin of goods or services. It can be a logo, it can be words, it can be pictures, it can be smells, it can be sounds, but it has to be used as a badge of origin that is put on goods and which will point back to the trademark owner. So is this a sign used in trade or commerce to indicate that all the goods with this sign are the same or that they're made by the same person? Step 2, what classes of goods or services will it be registered in? I have a link there to all the different classes, but basically you have to select what classes you register your mark in. So if you're using your mark on clothing, there will be a class of goods relating to clothing and you will register that mark in relation to that class. What that means is that somebody else might be able to register the same or a similar mark for a totally unrelated type of goods in a different class. For example, car parts, right? It will not confuse members of the public if there are women's clothing with a logo and then car parts with a very similar logo. People are not going to think that they come from the same person. So we like to open up as much as possible that people can use similar marks so long as they're not confusing members of the public. And then you need to make sure that the mark is not going to get rejected by the trademark office or opposed by somebody. for any of the reasons listed there. So if the mark is not able to distinguish the goods, usually because it's too generic, it might get rejected. If the mark is scandalous, it will get rejected. So if it's a swear word, if it is likely to deceive or cause confusion, or if it is too similar to a mark that is already registered in the same or similar class of goods or services. And I have a link there to the trademark register, which anybody can search for existing marks. That's all you need to know for registration, those 3 steps. For trademark infringement. So a trademark owner has the exclusive right to use the mark in trade or commerce in relation to the goods or services for which it is registered. So if you're looking at trademark infringement, what you want to look at first is whether the mark that the person is saying is infringing their right is being used in relation to the same goods or services or closely related goods or services. So if I have a mark registered for clothing, is somebody else using their mark on clothing or on shoes or on anything related to clothing in a way that I feel might confuse consumers into thinking that our 2 marks are connected, right? So you want to look at the type of goods and services first, and are they close or the same? And then the second step is to look at whether the allegedly infringing mark is substantially identical or deceptively similar to the registered mark. Substantially identical means basically that the marks are exactly the same when they're compared side by side. Deceptively similar means, would an ordinary person with ordinary memory be confused that these 2 marks are the same or they're connected? The marks don't have to be compared side by side for deceptively similar, because we're looking at the impact on a person's memory. So if I'm remembering the trademark for Coca-Cola and I go into the shop and I see a can of cola drink that is red and that is very similar cursive writing to Coca-Cola, maybe a very similar word, maybe it's Coca spelt with a K, am I going to be confused that that drink has come from the Coca-Cola company or is related to the Coca-Cola company? If the mark is substantially identical or deceptively similar, then you have a trademark infringement unless there is a defense. And these are the defenses. It's okay to use a mark in good faith if it is that person's name. It is okay to use a mark in good faith to indicate the kind, quality, purpose, geographical origin, or characteristics of the goods or services. So to say, this drink is very similar to Coca-Cola, that's okay, that's a descriptive use. Use in good faith to indicate accessories or spare parts. So I can use the Microsoft or Apple logo to indicate that I am selling spare parts or accessories that work with Apple or Microsoft products. You can use a mark in comparative advertising. So Pepsi can use the Coca-Cola trademark to say we think Pepsi is better than Coke. And use on secondhand goods. So if I buy a pair of Levi jeans and I chop them off and sell them as denim shorts, it is okay to keep the Levi jeans trademark on them because these are secondhand goods, but they're still Levi jeans. All right, so look at it, whether any defenses apply, conclude about whether or not there's been trademark infringement, and then if there has been, the remedies will be an injunction and damages. All of the extra details for trademark and all of the areas of law I'm going through are covered in the workshops and the podcasts for week to week of this semester. I'm going through this pretty quickly, but that's because it's a review class. All right, last area of IP we looked at were designs. Designs are pretty straightforward. They protect the visual appearance of goods, shape, pattern, ornamentation, etc. To register a design, the good must have a commercial application or use, and the design must be new and distinctive as compared to designs that already exist. You should be aware of the design copyright overlap. So if I'm designing a dress, like the little orange icon I have there on the slide, then my drawing of that dress, as I'm designing it, will be an artistic work that is protected by copyright. But the law says that you can't have both copyright and design protection, because that would be double dipping. So if I decide to register my dress as a design, then I lose copyright protection. Or even if I don't register the design, but I mass produce that dress, mass produce means 50 or more items, then I automatically lose copyright protection. If I register my design for the dress, then that gives me the right to commercially use, sell, or license that design for a period of 5 years. And if anybody else tries to do that, to use or sell my design, then that is an infringement of my rights and I can sue them. And that's all you really need to know for designs. And that concludes our IP content. After IP, we moved on to contract. We looked at contract formation and contract terms. So if we start with contract formation, you want to look at, has there been an offer and has there been an acceptance? The acceptance can be by words or conduct, but it must be unconditional. If it is a conditional acceptance, then that is a counter offer. A counter offer is not an acceptance, it is a new offer back to the first person, and then the first person has to accept the new offer for there to be a concluded agreement. Sometimes people will reach an agreement verbally, but make it subject to a written agreement. So say something to the effect of, I'll get my lawyers to write up a contract. If this has happened, then you need to look at the context of their verbal agreement and decide whether or not they intended to be bound immediately or whether they only intended to be bound once the written contract was done. That is relevant because if there is a breach of the contract in between the verbal agreement and the written agreement, then you need to decide whether that is something that the person can sue for under law. All right, for a valid agreement, there must also be consideration, which is the quid pro quo. Each person must be giving something to the arrangement. Usually this is payment in return for goods or services. Step 5 will not arise in every situation, but in situations involving a minor, so a person under 18, there may be an issue of capacity. Minors do not have the capacity to enter contracts unless the contract provides them with necessary goods or services, or the contract is for their employment and it benefits them. If it is either of those two types of contracts, then the minor will be bound by the contract. And then, of course, you conclude, has there been an agreement? Sometimes there are statements or actions done outside of the agreement that may impact on the relationship between the parties. 2 things you need to know here: equitable estoppel and quantum meruit. Equitable estoppel occurs where party A has made an assumption and has relied on that assumption to their detriment. And that assumption was encouraged or generated by party B. Party B knew that party A would rely on that assumption, and they did nothing to stop party A from suffering detriment. If that has occurred, then party A may sue to have their assumption or expectation fulfilled by party B. So maybe party B encouraged them to believe that party B would do something, and then party A relied on that and went and got a loan or started production of something. Then they might be entitled to make party B do what they thought party B was going to do. If it's not possible to have that assumption or expectation fulfilled, then they will receive a monetary remedy instead, so damages. For quantum meruit, this occurs if party B asks party A to do some work and party A does it and party B accepts the benefit of that work. Then even if there's no contract, party A will be entitled to reasonable payment for their work from party B. So party B says, can you go do this job for me? And the implication is that it's a paid job, not a favor. Party A then goes and does that job, which benefits party B. Then party B will be required to pay them for that work. All right, so say we have a agreement, then we need to check that there's no reason that that agreement might be invalid. There are 3 reasons why the agreement might be invalid. The first is misrepresentation. So party A has made false statements to party B that caused party B to enter the contract. If that is the case, then party B will be able to get out of the contract. So this includes false statements, half-truths, failing to collect false information, or if the parties are in a relationship of reliance, then it might include silence. So if one party is the manager of the other party, or the agent, and the manager or agent knows something but they just don't tell their the person that they are managing or representing, then that can be a misrepresentation. So any misrepresentations that cause a party to enter a contract will render the contract void. A contract might be invalidated because of undue influence. So they were influenced to enter the contract by somebody who had power over them, essentially, or influence over them. So a parent's influence over a child, an agent or manager's influence over the person they are representing, a lawyer's influence over a client. Even if there's no misrepresentation, if the only reason the person entered the contract was because of the influence or the pressure placed on them by the other person, then that might also invalidate the contract. And the last one is unconscionable conduct. So a person has a special disadvantage. This is things such as old age or some sort of infirmity or condition or disability, which means that they don't really understand what they're doing. And the other party takes advantage of that disability or disadvantage to get them to enter into the contract, then that will also render the contract void. Right, so the result of any of those things is that the contract is voided or rescinded, which means it just goes away, it's not enforced, unless the innocent party decides to continue with the contract. They do have that right to choose if they want to. And then you reach your final conclusion, which is whether or not there is a valid contract, taking into account all of those preceding steps. And on this slide, I've just put this little flow chart that comes from that relevant week 10 class about the steps to go through. Offer and acceptance, create legal relations, consideration, and then those 2 things about if there is a contract, is there anything that might cause the contract to be void? If there's not a contract, or if there is behavior outside of the contract, does that fall within either equitable estoppel or quantum meruit? All right, and the very last thing we looked at in week 11 were contract terms. You need to be aware of these two types of terms. Exclusion clauses. These are clauses that exclude a person from legal liability for actions. Exclusion clauses may be very broad, and that is still valid, but they can only exclude liability that would have been contemplated by the parties when they entered into the contract. This is called the four corners rule. That refers to the four corners of the contract or of a piece of paper, right? Only things that they would have thought might happen at the time they entered the contract can be covered by the exclusion clause. The other type of clause is a restraint of trade clause. Restraint of trade clauses are always void unless they are very narrow, unless they are only as narrow or as wide as is needed to protect the legitimate trade interests of the party. You want to look at things like the duration, how long the restraint is for, the jurisdiction, how wide the restraint is in terms of the area, and what activities will be restrained. And only very narrow and limited restraint of trade clauses will be allowed. All right, and then the last thing we covered was contract enforcement. This requires so this is what you look at if a contract has been breached. If you have a contract and a person has breached one of the terms, then you want to decide what will happen next. And what you need to do first is look at the term or the clause that was breached and decide whether it is an essential term or an inessential term. We do this by asking whether or not the party would have entered the contract in the first place if that clause was there or not. If they would not have entered the contract without that clause, then it is an essential clause. And breach of that clause will entitle them to terminate the contract and sue for damages. If they would have entered the contract anyway, even if that clause was not there, then it is an inessential clause, and only a serious breach of that clause will allow them to terminate the contract. And a serious breach is one that deprives them of the whole or substantially the whole benefit of the contract. But if it's only a minor breach that makes them lose, say, some money or some benefit, but not the whole benefit of the contract, then this is not a serious breach and they're only entitled to monetary remedies, not to terminate the contract. And that is it. All of the content covered this semester in 1 hour. I hope this review is useful, and please let me know if you have any questions. Thank you.